with no extra requirements of extracts. We submit, my Lord, that at Mutunga rules regulate petitions, and the civil rules can only apply, if at all, where there is a gap. We submit that there is no such gap. And lastly, my Lord,
I was just about to ask.
Yes, my Lord.
Lastly,
there is no evidence before you that those email addresses do not belong to those public offices. Article 245 of the Constitution establishes the office of the IG of Police and in the National Police Service, and he is the commander. He is the one responsible.
what is the first response?
Respondent. Yes, my Lord. So, if that office is served, my Lord, then such a high-ranking officer can be accessed through that email. How else can Kenya ranking officer in order to effect service? I will end, my Lord, by referring to a decision that I am the youngest here on the bar. That the prayer to set aside is a discretionary relief. It must be demonstrated that there is hardship.
There are two positions.
Yes, my Lord.
Position.
Shavas Mbogo and another of 1967 East Africa. At page 116, my Lord. 116.
I was trying to see whether you remember.
Yes, my Lord. So the prayer to set aside is a discretionary relief, and it can only be granted where there is extreme hardship or a miscarriage of justice, my Lord. But they cannot be delivered or granted where they are being sought to obstruct the delivery of justice. Yes. Kenyans, my Lord, and the families of the second to fourth petitioners want to know where their siblings are. That is the main goal of this application and petition. Setting aside those orders will not lead to that result, my Lord. It will actually allow the bleeding of the Constitution. And as Senior Thande Kuria submitted the jurisdiction to do injustice, we submit that the High Court of Kenya established under Article 165 does not have the jurisdiction to allow for the violation of the Constitution. That will be all from us, my Lord. Thank you for the opportunity.